I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even, thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You've never talked to Senator Toomey about it?
I never discussed it with Senator
And
Toomey.
you don't
no.
know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
In a fiery Senate hearing that left the room silent and stunned, Senator John Kennedy took aim at a judicial nominee with a track record that's hard to ignore and even harder to defend. What followed was a relentless barrage of facts, court reversals, and pointed questions that exposed glaring cracks in the nominee's legal history. This was no ordinary clash. This was Kennedy on fire. Senator Kennedy began calmly, almost curiously, asking the nominee if she remembered a case called Potter County. She hesitated, recalling vague details. Kennedy reminded her she was reversed. She stammered again. And just like that, the gloves were off. One by one, he began listing cases. Each time, the answer was the same: reversed. Partially or entirely, the nominee's decisions had not held up on appeal. Let's dive in.
Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay, and you were reversed, is that right?
I believe that was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
I don't recall in that case if the report and the recommendation was adopted in full or not adopted in full, but yes.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too, weren't you?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct? Yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different. The district court declined to adopt the report and
The
recommendation.
higher court
in
said
full.
you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Shanias are pro se plaintiffs who have brought a number of cases, so I'm not sure which one you're referring to, but yes.
I'm just curious, you were reversed in that case too, were you not? In
part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes. And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Well, the Third Circuit said you failed to cite, analyze, or properly apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to decline to adopt my recommendation, yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing fee, and where I had recommended that the case be dismissed, he granted the petitioner 30 days to correct that.
So you were reversed in part.
Yes.
Okay. Do you remember a case called McCracken v. Fulton County?
Yes, I do.
You were reversed in that case too, weren't you?
I believe that was in part, yes.
You remember a case called Bird v. Britton?
I do.
And were you reversed in that case?
In part, yes.
Okay. You remember whoa, I'm sorry. I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You've never talked to Senator Toomey about it?
I never discussed it with Senator
And
Toomey.
you don't know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
I am under oath, and I know I did not speak with Senator Toomey about his reasons for not.
Was Senator Toomey's concern that you were unqualified?
Again, Senator, I did not speak with Senator Toomey or his staff about his reasons for not supporting me.
Okay. Thank you, Mr. Chairman.
In a room where precision matters and honesty is non-negotiable, Senator John Kennedy delivered a performance that wasn't about grandstanding. It was about truth. With calm but piercing questions, he laid bare a record that should concern every American. A nominee with a stunning number of reversals, including cases involving constitutional rights, serious criminal matters, and even one tied to child sex abuse cover-ups. Each reversal wasn't just a technical error. They were clear signals that this nominee consistently misapplied the law, failed to follow precedent, and showed a troubling pattern of poor judicial reasoning. And when asked directly, she had no real defense, no transparency, no accountability, just vague recollections and uncomfortable pauses. But Kennedy didn't flinch. He walked the nominee and the American people through case after case, exposing not just errors, but a lack of professional introspection. When pressed on why a sitting senator had once blocked her nomination outright, she claimed ignorance. That silence spoke volumes. Senator Kennedy wasn't just grilling a nominee, he was defending the integrity of the federal bench. He reminded everyone watching that confirmation isn't about politics, it's about competence, credibility, and character. And when a nominee falls short, it is not only right, it is essential that someone stands up and says, "This is not good enough." And that someone was Senator John Kennedy. In a time when trust in institutions is fragile, Kennedy showed exactly why scrutiny matters. He asked the tough questions others wouldn't. He exposed the facts others ignored, and he made it crystal clear. The American judiciary is not a place for second chances. It's a place for the best of the best. Once again, Kennedy proved he's not just a senator. He's a watchdog for the truth and a voice for the American people.